Felony mediation, which also has been successful in moving cases more rapidly through the system. This program offers circuit judges the opportunity to use felony mediation to address overcrowded dockets and overcrowded jails. Judges in several jurisdictions have held felony mediation days, which allow several cases to be mediated over the course of a single day. With an 88% settlement rate, the cases are mediated by a neutral senior status judge. Kentucky is one of few states that offer the program, and it has received national attention for its effectiveness.
Defendants and their victims have their day in court.
They get to see the strengths and the weaknesses of their case.
It does keep our dockets up to date.
They get another judge's point of view on their case.
Everybody is more involved in the actual process.
I believe that felony mediation enhances justice.
I became the circuit judge for Boone and Gallatin County in 2004. When I came on, found out that the docket had been very congested. Boone County had undergone tremendous growth issues. In 2004, the average circuit judge in the state was handling 1,074 cases. That's new case filings. Boone County for that year had new case filings of a little over 2,200.
In an average motion hour day, we can have upwards of 100 cases. When you have 100 cases, there's literally only a couple minutes for the prosecution to talk to his witnesses and then run back to me, give an offer if they're going to give a plea offer. And nobody gets an opportunity to really be heard. My clients usually don't get to say anything but go through the plea process in front of the judge. They really don't get to voice their side at all.
When I came on as the circuit judge, the agency of the courts had started a new program called civil mediation, and I contacted the agency of the courts to see if I could be one of the first counties to have that program, and they agreed to do that. When they came to do that program, I wanted to do, instead of 5 days of civil mediation, I wanted to do 4 days of civil mediation, 1 day of criminal mediation. The problem is they weren't set up to do that. They didn't have the authority to do criminal mediation, so I decided to do the program myself.
Public defenders especially were helped out a lot by the first mediation because it was mainly their cases and they were terribly overloaded. Both parties seemed to be happy with the process. It gave them 1 day to just sit and go through, 10, 15 cases in 1 day. And so it helped the docket and the congestion that we had with our criminal docket.
So we did it that first time, and it went really well, so we decided to do it over the next 4 years and do a program in which we would study criminal mediation. The agencies of the courts would come and observe it, and at the end of 4 years we made a report, issued our findings and recommendations to the state, and that's when the state took over the program.
If a judge is interested in having a felony mediation, they can contact me at the administrative office of the courts. I will set up a date that is good for everyone who is going to be involved in the mediation process to attend an orientation.
At first I had a little trepidation in terms of worrying about confidentiality and other issues. I wasn't sure how the process worked.
I was a little bit concerned at first, but then I went forward with the training process that the administrative office of the courts did, and I was willing to give it a try and talk to my clients about it.
I became a full-time prosecutor about 3 years ago. Before that, I was in civil practice for 20 years. Had great success with civil mediations. My thoughts were from the beginning that I thought it was going to be a great asset to the criminal process.
I was very excited about the prospect. Anything that can help us keep our backlog up to date and speed felony cases through our courts, I'm willing to try.
The initial mediator, I went to Judge Ray Late. At first we just got 2 judges who would come and help us, but after we did the first mediation, we decided, I sat down with the Commonwealth Attorney, sat down with the Public Advocate's Office, and we determined that we wanted to use judges who had been circuit judges, who had had training already in civil mediation, who had been prosecutors, who had been criminal defense attorneys.
Initially, when I was called to participate in this project, as I was driving to the community we were to serve that day, I could not wrap my mind around the fact that we were going to another circuit to intervene, I felt, in an elected judge, an elected Commonwealth attorney, and a public advocate or a private lawyer's responsibilities there in that community. When I got to that courthouse, I had about an hour to review the files that I would be specifically responsible for. And when I reviewed those files, I saw that many of those cases had some age on them. I saw that in some cases they were crimes where family members victimized other family members. And so they had some nuances and some characters that made characters that made them a bit different than the run-of-the-mill theft by unlawful taking, than the run-of-the-mill burglary. And so I could see that there was a possibility to discuss that which would work justice for the community and that which might work justice for the individuals involved.
It's really important for a criminal defendant to see a judge as the mediator. For one, there's a certain amount of respect that all criminal defendants give to a judge, whether they're retired now or not. I think that judges who've been on the bench long enough to retire have a certain demeanor and a certain respect that's due to them, and so my clients recognize that.
They get a chance to talk to a circuit judge and to actually tell their defense without waiving their right and letting me know their defense. The defense part of the case is presented outside the presence of the Commonwealth's attorney.
To have somebody actually listen to them and they feel like they matter, that somebody is respecting them, respecting their view, giving them the opportunity to say, this is what went on from my point of view, and have somebody listen to them and then work back and forth between us and the prosecution and their witnesses.
And in some cases, the Commonwealth attorney actually will find out through the mediator that a plea bargain might need to be considered, and the Commonwealth's offer might be too strict because the defendant has a decent defense, of which the Commonwealth would otherwise find out the hard way at trial.
In my mind, my role is not to serve as a judge, although the benefit is I probably have a good idea what a particular judge might think about a particular case, probably have a pretty good idea about the Commonwealth attorney's perception of his or her case, and probably have a good idea about the defendant's opportunity to defend himself or herself, and the legal issues that might lie within that particular set of facts.
The best thing about criminal mediation that I have personally experienced is the opportunity to sit with a client who had some really good facts that would have come out in mitigation at trial, but inevitably he would have been convicted by a jury. For him to be able to give voice to those things, the benefit for my client was he didn't get the number of years that he would have received at trial, because the ultimate conclusion of the mediation was a lesser term than the minimum that it would have been at trial. And I don't mean to imply that everyone gets a better deal at mediation than they would necessarily at trial, but here in Kentucky we have persistent felon offender laws, and you kind of get to know your juries in your local areas and what their take on criminal activity is. And sometimes with a persistent felon offender law, we can either amend it through negotiation, or it can be dismissed through negotiation. And the particular instance that I gave involved a gentleman who was a persistent felon offender, but his prior felony was a child support felony, flagrant non-support. It wasn't another drug felony, it wasn't a violent offense, and by looking at the prior felony and by looking at all the good things that he had done in the last 2 years, the police officers authorized a different conclusion than what was being offered in court, and it turned out that it was less than what I believe he would have received if he'd gone to trial.
We had, I think we did 19 cases the one day we did do the criminal mediation. 18 of the 19 cases were settled that day. I think it's a really good program.
I look right now, I believe that criminal mediation, another benefit of it, besides reducing the dockets, is I think it really assists the victims in restorative justice.
I think it's very good for the defendants and for the victims because they both have a say-so. We have cases where they've had apologies. Simple stuff that they don't get just by simple incarceration or probation.
Our role as a prosecutor is not to get convictions, but to see that justice occurs in this system. And I do believe that felony mediation is a good tool to ensure that justice does occur in the criminal justice system.
I feel that justice is served with felony mediation because particularly a victim in a case is able to come in and express their feelings about a case and be involved in the process more as to the resolution, particularly in cases involving sex crimes, which are very emotional cases anyway, and that gives them an opportunity to still be involved in the process, even confront the defendant without having to go through the actual jury trial process, which can be very traumatic. So particularly for those cases, it is definitely serving justice.
Very often in our courtrooms throughout the Commonwealth, the trial outcome is that which serves the rule of law. It is not necessarily a servant of justice. Justice can be done when the needs of the participants and the needs of the community are met, when thoughtful people bring the law and facts to bear and think about them in a new way.